Hi, I'm attorney Gregory Dell here with attorneys Stephen Jessup and Alex Palomara, and we're going to talk about long-term disability claims for IT professionals, software engineers, computer specialists. I mean, this is kind of a broad category of occupations because there's nuances within each one, but it's a lot of the employees from Microsoft, from Cisco, from any company that has an IT professional that manages the network. I mean, everybody, even our own law firm, we have an IT professional. So I don't want to offend anybody by calling you an IT professional where that may not be the same as an engineer because I know it's very specific. But bottom line is it has something to do with a computer, networking, and what it takes to run a business or run an operation for a retail business, a website, things like that. And what it comes down to, Steve, is that for the most part, there's an occupational classification for these types of jobs because of the fact that disability carriers, when looking at the definition of disability, look at how these jobs are performed in a national economy. And that's when it gets down to where then we can go into the specifics and be like, look, not all IT professionals, not all engineers, not all software developers are the same just sitting at a desk. But what is your experience as to how these jobs are classified by most disability companies in the national economy?
I think the biggest thing you're going to see in any of these denials are they're going to strip what you do from the actual nuts and bolts duties down to what the physical demand is. More often than not, when we get a denial for someone who's a network engineer, software engineer, IT, they'll say, oh, your job's light duty, and you should be able to do a light duty occupation, which is like lifting up to 20 pounds. And they don't go into the nuances of the job. It's just saying, could you physically perform the tasks at hand? So they really strip it down to there without necessarily taking a look at what the person's doing day in, day out. I've represented clients who've worked for Verizon and stuff, and they have to do their duties, what they do at night. They're doing all their updating and stuff at night, and fiber optics, laying certain things. There's so many differences into it, and I have family members who are in that industry, and it confuses me as to what they do because it's so nuanced. But the insurance companies will use that against you by just trying to wrap it all up in some clean, simplified box and say, well, you should be able to do sedentary light duty work, so you should be able to do your job.
So Alex, this classification of light duty, sedentary, can you explain what that is and why that becomes an important terminology when applying for long-term disability?
Well, the insurance companies love to call most, IT jobs, a lot of them, like you said, light, but most of them try to even call sedentary. Mm-hmm. And a sedentary job, the way the insurance company looks at it is that if you sit all day, it's a sedentary job. And if you have the ability to sit all day, then you're not disabled. Mm-hmm. Or if maybe a light job is something I think you can, carry 20 pounds on a regular basis or an occasional basis. And if you can carry something 20 pounds, and 20 pounds is next to nothing. Mm-hmm. They say, oh, you can do your light duty job because your doctor said you can carry something for 20 pounds. So the insurance companies, what they kind of do, and Steve pretty much mentioned, was they dumb down what your occupation is. They look over so many things. They try to be as general as possible and not specific as possible. They use what's known as the Dictionary of Occupational Titles, and they kind of use a general terminology of what your job might be, not your specific job, and your job probably won't even fall into that specific category that they're trying to utilize to deny your claim. But they use this Dictionary of Occupational Titles just to say, hey, this is what we think your job is, and you have the ability to do this job because you have the ability to sit there all day or lift 20 pounds. It's kind of a joke, the fact that they use the Dictionary of Occupational Titles for some of these occupations, some of our clients' occupations, it's a joke that they try to use.
Yeah, because that was written well before some of these occupations existed. Right. The leaps and bounds in technology and stuff, it's completely different. And going back to that Dictionary of Occupational Titles, or ONET, when you read through what this generalized thing is, at the bottom it'll say STR, strength, and that's where you get the sedentary and light, and that's where the insurance companies really kind of justify their basis as to why they can go on these physical demands.
Yeah, but Steve, how do you look at any of these computer professionals, network professionals, and basically say, okay, they're saying you can sit for 4 to 6 hours. Now, when they applied for these jobs, and they looked up the criteria for the job.
I always say, as a lawyer, my job's sedentary, so if I could just had to sit all day and lift 10 pounds frequently, life would be a lot easier. Same for these people. It's so cognitively demanding, right? If it was as simple as being able to sit for up to 6 hours a day, everyone would be, in these jobs. It's so much more than that. So when looking at it, if it's a pain-based condition, so there are going to be physical limitations to what they can do. And I mean, just the other day I was installing new monitors in my office, carrying them back. This stuff it's not light, it's not sedentary levels.
Right.
And when they're, for instance, having to, say, in an office setting, update all the software, update all the computers and stuff, it gets physically demanding for the people. So there is that aspect of it, but then how is the physical problems, the pain, maybe the medications, how is that affecting the ability to focus? These jobs are so based on reading of codes and applying, my family members, they speak and it's like a foreign language sometimes to me. So how does it impact their ability to concentrate through those things too? So it's really, really nuanced in exactly what that person's doing, the setting in which they're doing. Are they just in one office space handling things? Or do they have to travel around a large facility to multiple facilities, especially for these larger corporations? So you really got to dive into it. And it's unfortunate there's no cookie cutter, case for someone in this profession.
But this head of this information technology category is monstrous. It's one of the most common occupations all of the world's largest companies in the world have these information technology specialists. I've represented people who have finance degrees, but they're the head of the the IT department, or you have huge consulting companies, the Ernst & Youngs of the world, who have these information technologies, who then have consultants who come in just to help do the information technology flow of how you run your operations. Every factory, how they're going to run their assembly lines, all these retail stores, every online stores, the Amazons, everything is based upon this. But now you get this person who basically says, yeah, I have to, for the most part, sit at a desk to do this type of job, but I can't focus after an hour. Mm-hmm. And how is that person who says, if I had to just sit in that chair for 4 to 6 hours, no problem. But where does the cognitive demand come into the equation? And how do you prove, Alex, that they're having this cognitive or focus difficulty, not brain damage, difficulty multitasking, remembering things, focus, all of those things.
Well,
how do you prove that?
Two things I utilize in my appeals and for my claims are, I'll use a vocational expert to help show the insurance company what the job duties actually are of my client, that you can't classify them in this dumbed down Dictionary of Occupational Titles definition. So you want to use a vocational expert if you can. Other thing is, to prove that you can't do those duties, the proof is in your medical records. I mean, as a claimant, it's your duty to prove to the insurance company that you are disabled. And your proof is in the form of medical documentation and support from your treating providers. So you need to go to your doctors and ask your doctors, what do you see? Here are my symptoms, or what have you diagnosed me with? What objective evidence do I have to prove this? If there's no objective evidence, then you need to get some testing done as soon as possible. Whether it's a back condition, you can do a functional capacity evaluation. Cognitive condition, there's neuropsychological testing to show that you have cognitive issues, memory issues. You have to do these different type of tests to prove that your pain prevents you from, even though you can sit there on medication for 6 to 8 hours a day, you need to have further testing to prove that your conditions prevent you from actually doing the specific duties of your own occupation.
And Steve, most of the IT professionals that we represent, they have been suffering with these medical conditions for years. Mm-hmm. So, or months. I mean, unless, someone has a catastrophic accident, that's totally different. I mean, bad car accident, they fall, they break, whatever, anything that happens at home, those kinds of instant injuries. But most of these are chronic medical conditions. And in the IT professional world, they're usually employees of other companies. And when they look at their employment records, first of all, they don't have a reduction in salary over the years because they're on salary. Their bonuses tend to remain the same, if not go up, yet they've been suffering for years. Now they come and file the claim. So the disability company says, well, your income hasn't gone down. You've been able to work with this. The medical records say 3 or 4 or 5 years. What's going on now? Because we don't see any change.
That's obviously one of the toughest things, and like Alex said, the medical records are so important, and even if the medical records are documenting the problems, at the end of the day, going back to what Alex was saying, this idea that a diagnosis doesn't equal a disability. I recently represented a gentleman who, after an accident, was wheelchair bound. He continued to work for well over a decade, filed the claim, was denied. Never missed work. He said he'd work later on his free time to try to get the work done, but when he filed his claim, he was saying, it's affecting my personal life. I'm having to work so much extra to get my work done, I have no personal life. And the insurance company, rightfully so under what the policy is, well, this doesn't, impact if you can't perform, your personal life. It's work related. So it is a really difficult thing to do because most people aren't in a position to be able to reduce the work. They make up for it by working longer hours to try to get the work done. Not to mention this profession in general is already working more than the typical 9 to 5 to begin with. So that can be a very, very difficult thing to do. Sometimes it's a matter of if you see a history of where they're using sick time, taking vacation time, you start to piece together a drawing back and they're using some of that time they have to try to focus on their health. And then maybe in doing that, that's where you start to try to set up, all right, maybe now is where we have the doctor say, you should probably stop working. So you really have to work with it to get that. So the insurance company just doesn't say, well, you've been able to do it, so what now?
But when I see those denials, when they say, you've been doing this with the same symptoms and the same diagnosis for years or months or whatever, what's changed? Sometimes I make the argument that the insurance company, that you guys are looking at it totally incorrect. Yep. Just because my client's been a hero for 3 months, 6 months, 9 months, or 5 years, you can't hold that against them. It's a testament to their credibility. A lot of people that are going to be watching this video have been suffering for years. And the fact that the insurance company has denied their claim for that reason and says, what the heck, I did something favorable for them. I could have made a claim 4 years ago. They could have been paying me $10,000 a month for the last 4 years. I saved them, $500,000.
And it shows that they want to work. They're doing everything they can to continue to work. But it's a last resort to file the claim.
One of the concerns, and you guys see this a lot, and with group policies, is that this person's been working for years with their difficulties, and they think I'm keeping up to speed, I'm doing what I need to do. But actually they are slipping and their employers start to recognize it, and then all of a sudden they get fired.
I see that happen all the time.
Okay, and then they call us and say, I got fired, I was suffering, and now I want to file. What's the challenge there, Alex, that person's, because ordinarily the disability company is going to say, sorry, you don't have coverage. So talk about that situation.
It complicates things. The insurance company can say you don't have coverage. They can say you're only filing this claim because you were fired. If you were not fired, you wouldn't be filing this claim. So they're going to think that's just not a valid claim for that reason. So you have to prove to them, and you have to do it through the proof again, through your medical records that shows you've been suffering from this conditions for a long period of time. Maybe we can get even some of your employment records that shows that you've been slipping, that your production has been slipping, or that you've been written up for missing work or for whatever it may be. There's ways to get around this. It does make it a little bit more difficult, but there are ways to get around it to prove to the insurance company that it's not a fraudulent claim, that the fact that you're fired is because of your disabling conditions. You have to use that argument and prove that the only reason why you were fired is because you were suffering from these conditions that affected your ability to work.
And to that too, I've even, with clients and discussed, sometimes when employers are letting you go because you're not keeping up and they know it's medical, employers are often worried about being sued for, wrongful termination. So in some instances, the employer will actually help push and get them the disability because they're basically insulating themselves from liability. Another thing that you see especially is, with some of these major tech companies, they'll do every year rolling layoffs. They'll just cut down the workforce, and people know well in advance when their last day is going to be, and then they say, well, I've been sick and I've been dealing with this, I want to file a claim for disability, and you get the same thing. Well, isn't it convenient that you're being, terminated your employment, and that's why you're doing it?
But at least that person had notice and can file beforehand, because technically,
you're at least legally you have there's no question about the coverage.
Technically, if you apply after you've been fired, your coverage ends the day you're no longer employed.
Yeah.
The other thing that's another issue is that in those rolling layoffs, they often do severance packages, and many of those severance letters have a waiver of your long-term disability claim or benefits.
Or they say any claims that you may have under ERISA, which is everything, your health, your dental, all that, your disability. And some employers will carve that out in the severance. But if a lot of people have signed it, and you see lawyers later on the defense side say, hey, listen, they waived all their rights to everything on this. So it's you got to be careful in signing those severance agreements as well.
The IT professionals, and what I like to do in these claims, because usually we see the denials come at the change of definition from the own occupation to any occupation, which usually says the inability to perform any job for which you have experience, education, or training, or the ability to earn 60% of what you were earning. A lot of people contact us before that comes up, but sometimes they contact us after. But what I like to do is anticipate that and prove ahead of time that the job is potentially a sedentary type job, or even if it wasn't sedentary, that you couldn't do any job, whether it was light duty or sedentary. So forget about the classification of the job when you're proving your claim and get to the point where you can't commit to any employer for more than 4 hours a day on any reasonable basis. And that's what it's about, being a reliable employee. Not that you can't go work an hour or two. Most jobs don't allow that.
No, you got to work 8 hours a day, minimum, 40 hours a week, week in, week out.
So a big tip would be is anticipate in your claim that it's about your ability to work with continuity and being a reliable employee, as opposed to getting caught up in, can I do sedentary, light, or medium? And that's the trick, is the carriers try to push you towards doing these categories, and they'll say, okay, we get it, you can't do light or medium, but you can do sedentary. Yeah. So if you plan for that, then you can avoid a denial in the future. And if you've already been denied, there's ways to get around that. But typically your claim was more shaped towards like a light duty. You got focused where the carrier wanted. Those forms they give you they're not even geared towards allowing for, you can't do any job. It's like, they basically put in a minimum, you can do sedentary.
Well, they give your doctor 5 boxes to choose, and the lowest one is sedentary and light, so there's not below sedentary.
Like Prudential's infamous for that.
So the doctor's thinking, well, this is the worst one, I'm going to check it. And then what Alex has said about doing vocational reports, a lot of times too in this profession, the transferable skills, especially if there's an income component to any occupation, often turns out to be basically the same job,
Right.
In the sense, like the only other thing they can do is basically the same type. So it's, like you said, setting that up in those vocational reviews can be wonderful, in establishing that.
All right, so there's so many, we're just scratching the surface. I mean, for computer professionals in terms of all the different issues that come up, and then we get into the nuances of which we have tons of other videos about how to fill out these claim forms and attending physician forms and, excuse me, strategies for appeals and lawsuits and applying. So I encourage you to seek out our other YouTube videos that we have discussing those issues. But most importantly, we always offer a free initial consultation. So no matter what stage your claim is at, feel free to give Stephen or Alex, myself, or any of our disability lawyers a call. We're always going to provide you with this initial free consultation, and we're going to let you know right away if we can help you. And if we can't determine it, we're going to let you know what we need so that we can give you an opinion as to how we think we can help you. Our clients are all over the country, and we look forward to the opportunity to discuss your claim with you.